Ademba Alan, Emmanuel Ongua,
We'll get it done.
Moving James Amoko,
Viva.
Benjamin Waura, Benjamin, Stephen Ooko, James Ochieng, Joshua Okayo,
Viva, comrade, viva.
Fabian Ochieng,
Viva, comrade, viva.
Dayo Ahamo, Dayo, Philip Onyango, Darian Mudvenu, Cyrus Waweru, Nicholas Karanja, Wayne Ouma, Okia Omtata. Kwa wale mliita majina, kuna mtu yote hapo chini ya miaka 18? Is there anybody who is under the age of 18 years?
Please the court. I'm Martha Karua, Senior Counsel, appearing with my senior colleague, Senior Counsel Kalonzo Musyoka, Honorable Eugene Wamaro, Honorable, not honorable, but Dewa is honorable, but the title is not there yet. Yes, the title is not yet confirmed, but he is indeed honorable. Simon Boro,
I'm present, Your Honor.
Simba, oh, John Minor,
I am present, Your Honor.
James Omamo, Kelvin Walumbe, Senator Manzo,
Present, Your Honor.
Ian Mutiso,
Present, my lady.
Kabata Mwaura for the Law Society. In another court. Mano Hussein.
Mano Jose, Your Honor.
Permit my poor eyesight. Your Honor, and Ms. Kabuda Mudama. Present, Your Honor. Anybody else have left out? Oh, we have Mr. Victor Kamau appearing on behalf of the Kenya National Commission on Human Rights. Anybody? Bob Okumu. Juan Shago. Your Honor, we have a preliminary objection to the charges, but in view of the time, we are wondering whether you could give us a date for the preliminary objection, but in the meantime, we can pass bail. And Your Honor, looking at the charges, you can see it's what one would call omnibus offenses, which the police use when there is not reasonable charge to prefer. Charges merely being used to ask for the holding of the accused persons in custody for 15 days. I've seen an affidavit suggesting that, which is really outrageous. So we'd like to ask, because our submissions on the preliminary objection will be lengthy. The accused persons have already been in custody for more than 24 hours, because the time they were arrested yesterday and the time they have appeared before you, which is 1:30, they've been in custody for over 24 hours. We would want the court's indulgence that we apply for bail, and you do give us a date for us to come ready for the preliminary objection to these charges. We do believe that the accused persons are before the court for being patriotic Kenyans and for being peaceful, for following the abductees, which is a matter of public knowledge, for staging a peaceful protest. So we are saying, in other words, the background to these offenses is a matter of public notoriety, which the court can take judicial notice of and allow us to go straight to bail application and to kindly give us a date when we can come and make objection to these very outrageous holding charges.
The court is to defer the hearing of this application. We want to reiterate that we are appearing for freedom fighters who are fighting to liberate themselves. So, Your Honor, the application is that we defer the hearing of this application and we grant bail to the suspects. Of course, Your Honor, I refer you to Article 49, Clause 1, Paragraph H, which provides that an arrested person has the right to be released on board or bail on reasonable condition, pending a charge or a trial. Pending a charge. That is the basis upon which our application is made. This is not the first application of this nature. They have been made previously, and noting that the application that we shall canvass in the future, if the court is obliged to hear us, they are only proposing petty offenses, misdemeanors. When you look at that, Your Honor, as against, again, Article 49, Clause 2, it provides that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only, or by an imprisonment for not more than 6 months. So, Your Honor, our application is well seated in within the four corners of the Constitution. You grant us bail pending the hearing of this application. The application has just been served upon us. The application presupposes to investigate petty offenses and will not prejudice the applicants in whichever manner if the application is granted. We must apply.
Before the offense is in the application so presented in court is the third interested party. Your Honor, in the said petition, Justice Bahati Mwamunye has issued orders that touch on the subject matter that is before you. That
Gigiri police station where Okia Ontaka was being held. They refused to let me. I was with senior counsel Aminwa, Degwantiro, and several other lawyers and civilians. They refused to let us see him. His brother was present with his medicines. They refused to give access for him to have his blood pressure medication. And later on, they transferred him to Kamukunji, and we were not able to see him, and I know he was not able to access his medicine. I'm bringing this to the attention of the court. One, he's been brought after 24 hours, because he should have been brought early morning, but they have delayed until 24 hours have finished. They held him incommunicado, and it's the same for all the other. I'm informed by my colleague counsels it was the same for all the others. In view of these illegalities and impunity, and the fact that it has already been mentioned that the way the affidavit is, you can clearly say see there is no offense disclosed. It's a fishing expedition. And if you look at Article 49, it's the rights of the accused, not the wishes of the police. Because this is a wish list they have brought that give us these people for 14 days. It's the rights of the accused or anybody held in custody. So the application is brought under sections that protect the rights of persons arrested, not gives the police the power to continue abusing the law. Article 36, not article, but section 36 of the Criminal Procedure Code also cannot come to their aid, and therefore urging you not to even go to consider bail, to just reject this application forthwith and set the gentleman, have I seen any lady there?
No.
The gentleman before you at liberty forthwith. And it's a matter of public knowledge that they were peaceful, they were seated demonstrating, but the police and administration in this country have criminalized legitimate activity. So instead of looking for the abductors and punishing them, they are punishing people who are asking why and where are they. So there is no charge here for us to discuss. Kindly release these persons, set them at liberty forthwith, let the police retrace their steps and come when they are ready. Actually, this is an embarrassment and an abuse of the process of the court.
By the defense counsel, I feel like we are already having the said application. I will agree with the prosecution that by allowing bond to the respondents hearing straight away defeats the purpose of hearing the said application, which centers around issue of custodial orders that is being sought by the investigating officer. Therefore, we direct that we proceed straight to hearing the said application and the responses can be taken and the court will make a determination of the same.
Most obliged.
Most of you.
We argue the application. So application. The normal thing is that accused persons or suspects can sit if they are seated, so please do sit where you are.
Application before this court. 6 for custodial orders. For the 23 respondents.
Amesema magistrate, unajua wakina Kalonzo walikuwa na apply juu wamesambiwa sahi wakuje wapewe time ingine ya kukuja kuargue. In the meantime, accused persons wapewe bail. But mama amesema juu ana feel ni kama washaanza kuiargue, waargue sahi alafu ende make decision.
Nairobi Central. Yana, in the first not to be what is in paragraph? Paragraph B. And it was supposed to be that. Paragraph B. The definition of the state of that is investigating offences of incitement to violence and disobedience of the law